Okay. There must be a proof of service somewhere. Exhibits. Here we go. Somebody from the prosecutor's office. That's all it says is prosecutor's office. Well, it must be this one. I see a Hillsdale phone number. I'm going to let that in. I don't know what this other one is, but I'll let it in as well. BIXD, who might that be? Lamson. Well, this is indeed challenging. I don't know who all to let in. Ah, here we go. Elizabeth Lamson. Not sure who that is. I'm not on the record yet, but I want to make sure I've got everybody in the courtroom that's on the Sheely file from Hillsdale. So, Ms. Lamson, you were on that file?
Yes, sir.
I'm not sure who else is. I'm looking in the waiting room. This is the first hearing I've held in this case that was recently reassigned to me.
Okay.
I've got someone in with it looks like a Hillsdale telephone number ending in 3307. What is your name?
This is Attorney Roy Brandis. I am guardian ad litem for the children in the matter of Sheely.
Okay, Mr. Brandis, good morning.
Morning.
All right, let's see who else is here. Who normally shows up at these hearings? I'm assuming there's someone from the prosecutor's office, but I don't know the names down there. I've also got a telephone number in of extension 6931. Can you identify yourself, please?
My name is Denisha Ostrander. I'm for the Barnett case.
All right. I'll put you back in the waiting room, but I'll put a name with the file so I know who you are. Thank you. Okay,
Your
and
Honor.
I'm sorry, Ms. Labs. Yeah, go ahead, Mr. Brandis.
No, this is Scott Smith, Your Honor. I identify as G. Scott's iPad 2. I represent the father, Robert Sheely, in the Sheely-Bostetter case.
All right, Mr. Smith, you know it's possible to change the name on your login when you do that. It's very helpful to the court when attorneys do that. I'm going to change it now because I'm not going to remember your name. Tell me it again.
Scott Smith, Your Honor.
Okay, Mr. Smith, good morning.
Good morning, Your Honor.
You're from Hillsdale?
Actually, Your Honor, I'm from the shores of Lake Michigan. I'm calling from Van Buren County.
Oh, okay. All right, let's see. Who's from the prosecutor's office? What name should I be looking for in my waiting room?
Typically it would be Jamie Wisniewski.
Oh, I see her. Great, thank you. Okay, good morning, Ms. Wisniewski. I'm about to go on the record in the matter of the Shealy minors. I want to make sure I've got everyone present before I do that. Do any of you expect anyone else to log in? It looks like the parents have been inactive. I don't see either parent's name showing up. I'm aware that there is a placement grandparent, I believe, but I don't remember the name off the top of my head. Would you expect that person to participate?
Yes, sir. She just texted me and let me know that she was trying to log in. It's Terry Kreps, Creps.
You know, I think I saw that name earlier. Can you give me her phone number and I can just try to call her? She can. Oh, here we go. I see her now. Okay, and I just let somebody in with an iPhone. What is your name, please? It shows we're connected, but apparently whoever's at the other end can't hear me. Anybody recognize that person?
Your Honor, the young man that you see there is Jack Shealy. He's one of the boys in the case.
Okay. Okay, it's showing now that it's trying to make an audio connection. We'll wait till that's established before we go forward. And you said Jack?
Yes,
All
Your
right,
Honor.
here we go.
And that's Mrs.
Looks like
Kreps right there.
Okay. Ms. Krebs, can you hear me okay? All right, you need to unmute. We'll fix that. All right. Anyone else that anyone is expecting to participate in this hearing today?
Yes, Your Honor. Deb Dix from Maury Spear campus. She would have Nathaniel Shealy with her.
Okay, and I see a Dix D. I'm going to let that one in. Okay, and you are Nathaniel Shealy?
Yeah.
You can hear me okay?
Yes.
All right. Anyone else that you would contemplate would be participating in this hearing today? Any of you? Okay, Shannon, put us on the record.
All righty. Go ahead, Judge.
Okay, we are now on the record in the matter of Jack and Nathaniel Shealy. I'm going to walk through the list of participants so that my clerk can get all of this down.
Thank you.
Let's see, we have Jamie Wisniewski representing the petitioner, Wisniewski. We have Roy Brandes, Brandes, guardian ad litem. Is that correct, Mr. Brandes?
That is correct, Your Honor.
We have Scott Smith, who I believe is an attorney for one of the parents. Mr. Smith, who do you represent?
I represent Robert Shealy, Your Honor, the father.
Okay. And let's see, we also have both young men are present, Nathaniel and Jack. And let's see, and also the placement, Terry, T-E-R-I, Kreps, C-R-E-P-S, is present. And let's see, Elizabeth Lampson, Ms. Lampson, Lampson, what is your role?
I work for the Department of Health and Human Services,
Which office are you out of?
Lenawee County.
Okay. All right, and let's see. Is Andrea Bricker on this file?
Yes, I'm Andrea Bricker. I'm from Hillsdale Integro, and I'm providing mental health services to Jack Sheely.
All right, and that's Bricker.
Correct?
I think that's everyone. Okay, this case was just recently assigned to me due to a disqualification, so I'm hoping, Ms. Wisniewski, you can bring me up to speed. It looks like the case has been open for some time, and there was a removal from one of the parents approximately a year ago. Is that correct?
That's correct, Your Honor.
And I did go back and read the supplemental petition, so it gives me an idea of what's happened. I note that it appears that the goal is guardianship. Is that correct?
It has been, yes.
All right. And can I ask why the goal is not termination, since the case has been open for so long?
Yes, Your Honor. After some lengthy discussion with the department and with the boys, they do have a very strong relationship with their family. They have a very strong bond with their mother, but unfortunately, mom just cannot get it together in a way that she would be able to take them on. So it was deemed not appropriate to seek termination because of that strong bond based on the boys' ages.
And the boys both have been very clear they do not want their mother's rights terminated?
I think they've both been pretty clear they don't want to be adopted.
Okay.
And
yes, who's
I'm
that?
sorry to interrupt. I'm Deb Dix at Maurice Beer Campus with Nate. Tasha Berger is a PO for Nate, and she says that she's in the waiting room and she can't get in.
She can't get in because I didn't let her in. Nobody told me her name.
Okay.
But now I will let her in.
Okay, thank you.
Could you say your name again, please?
My name is Deb Dix, D-I-X.
And what is your role?
I am the boys wing counselor here at Maurice Beer Campus, and Nate is with me at the facility.
Right. Okay. And someone told me, Ms. Berger, that you were on this case.
Yes, I am, sir.
Tasha, T-O-S-H-A, Berger, like the Big Mac.
Yes, sir.
And I'm sorry, give me your role again.
I am Nate's probation officer from Hillsdale County Juvenile Court. I am the intense juvenile probation officer.
Oh, okay. Great. Now I think we finally have everyone in the room. As a first order of business, let's see, this is probably directed to you, Ms. Lampson. For future hearings, would you please be so kind as to use DHS 1281 for your court report? It's what I'm accustomed to seeing. I look for the specific information that's in the various categories of the form. It's challenging to go through parent agency treatment plans and to pull out recommendations, et cetera. In this case, it does not appear that there are any recommendations currently for the parents. Is that correct?
Yes, Your Honor.
And that's because the goal is guardianship, not reunification.
Correct.
All right. Nathaniel is currently in a residential placement, correct?
Yes.
And how long has he been there?
He has been there just over a year. We are actually looking at discharge coming up in December.
Based on satisfaction of all the requirements of the program that he's engaged in?
Yes, Nathaniel has come a very long way.
Great. And discharge would mean placement with his brother at the grandmother's home?
We are exploring that possibility. We are also exploring other foster care options, but we are really trying to get Nate placed back in the community that he was removed from.
Since guardianship is the goal, who is the guardian that everyone has in mind?
So when the boys' permanency goal changed to guardianship, Jack was residing with a licensed foster parent, and at that point in time, the goal was for Jack to be placed in a guardianship with a licensed foster parents, and then the goal was also for Nate to join Jack at that foster home upon his discharge from the Maurice B campus. In September, there were some incidents at the foster home, and Jack had to be removed from the home, and he was then placed with his grandmother, Mrs. Krebs.
Is Ms. Krebs licensed?
No, she is not.
Is she eligible to be licensed, or are there some barriers?
I don't believe that her home would actually meet the requirements for licensure.
Was this a court-ordered placement?
No, Your Honor. It's a relative placement.
What's your long-term plan for Jack?
Our plan for Jack right now is to pursue guardianship with Mrs. Krebs.
Okay. So let me hear first from Mr. Brandeis. So Mr. Brandeis, you've been LGAL for some period of time?
Since the very beginning, Your Honor.
All right. And are you supportive of the goal of guardianship as it has been elaborated on by Ms. Lamson on the record today?
Your Honor, in concept, I agree with guardianship simply because a recommendation of adoption I don't believe would be acceptable to either of these boys who are older. However, there is some information which has been left out. Although Nathaniel has made wonderful progress at Maurice Spear, and the recommendation is for his release, frankly, I have not been advised of any potential placement after release. I don't know that Terry Krebs is an appropriate placement. Jack Shealy has been charged with a criminal sexual conduct offense. Judge Bianchi has also disqualified herself from that case. It has been assigned to your colleague in probate court up in Jackson. We have had a pretrial conference, and we'll have another conference set for 1 week from today. I don't know what the potential outcome of that is for Jack. That could also affect his placement. So although I am supportive of the goal, as a practical matter, I'm not sure that it's realistic to say that we know exactly who is going to be named as guardian for placement of one or both boys. We'd like to keep them together. I am concerned about placement of both boys with Terry Krebs. I don't know what's going to happen to Jack Shealy in the long run with regard to his criminal charge. So I think this case is in a state of flux, and it needs to be examined much more closely in the upcoming months.
And so I actually am presiding over Jack's juvenile case, and as with all juvenile cases that I preside over, I delegate the responsibility for that to a referee who frankly is far more familiar with juvenile court procedures and juvenile law as it pertains to delinquencies. She graciously agreed to handle that for me, but ultimately I'm the one who has to sign off on the orders, and if there is demand for a judge to try the case, I would be the one that would be trying it.
Understood.
Okay, Ms. Wisniewski, do you have anything to add?
Your Honor, I do believe Ms. Lamson submitted that court report. I don't know how you procedurally enter that into the record in your court, if you want me to introduce that as an exhibit, if you just accept it on the record. So if you could provide me some direction in that area.
All reports that are submitted are accepted. We place them in the social file, as with every case. I don't typically mark them as exhibits. I'll ask, does anyone have an objection to the court's admission of the court report?
No objection.
Your Honor, Scott Smith on behalf of Robert Shealy, I have no objection to the court's receipt of the report.
All right, so there being no objection to the recommendations, I believe they are appropriate. They will be included in my order after a dispositional review. We will, normally I schedule a next review hearing 3 months out. I will let all of you know if there's ever a need to advance something on the docket. Just get a hold of my clerk. She handles all the scheduling of neglect matters. And if you need to be advanced on the calendar, just let her know. That's Shannon Carroll. Anything else the court needs to address today?
No, Your Honor.
Very good. Thank you. Boys, do either of you want to say anything?
No. No.
All right. I want to make sure you understand that the purpose of this proceeding is to pursue what's best for the two of you. So I'm always interested in hearing what you think is best for you. So I always give you a chance to talk if there's something you want to say. Thank you all. This concludes the hearing. Our next review hearing will be.
There's the order right in there. I don't know.
Okay. Thank you. Sorry. February 23 at 8:45. Thank you all. Have a good day.
Thank you.
Your Honor.
Yes? Oh, okay. I think someone was just thanking me and got clipped off.
Okay.
All right. You are all excused. All right, let's get Ms. Denke. So who all is on the file we talked about yesterday afternoon?
My client's in the waiting room, David Allen Barnett.
Your Honor, I am as
Okay.
guardian ad litem, Michael Kelly.
All right, and these are the Bliss, Schuler, and Harrington minors?
Yes, Your Honor.
Yes, Your Honor.
Madison Bowen is the worker, Your Honor.
All right, let me get her in. Let Mr. Hotchkiss in just so he can be here.
And then the other mom, I don't know if she's in the waiting room, is Brittany Barnett.
I don't see anyone by that name, but I do see a telephone number. Let me see who that is. Telephone 6926. What is your name?
Mom, Jessica Chambers.
And I'm sorry, say that again.
Mom, Jessica Chambers.
Oh, okay. All right, we're handling a different case now. So I'm going to put you back in the waiting room.
Oh,
But
sorry.
I know who you, that's okay. It's not your fault. Okay, let's see. Well, I now have another number in there. Let me see who that is. Telephone 3928. What is your name?
Stephanie Reyes.
Okay, Ms. Reyes, I'm going to put you back in the waiting room. I'm going to label this so I know who you are.
Okay.
All right, and I don't see any, well, let's see. M. Johnson, is that a parent?
It should be, Your Honor. Should be Marissa Johnson.
On this file, or these files?
Yes, set for 9:30, Your Honor.
Not on the files that the court just called, though, Your Honor.
Oh, okay.
I'm
That's
sorry,
what
I
was
tuned
asking.
in late.
That's all right. I'm going to put her back in the waiting room as soon as she gets here. Ms. Johnson, well, I'm just going to put her back. We don't have an audio connection anyway. Okay. Can each of you on this file please identify yourselves for the record?
Matt Way, Prosecutor's Office.
Susan Day. Go ahead.
Madison Bowen with Department of Health and Human Services.
Susan Danke on behalf of David Allen Barnett, father.
Mike Kelly.
Denisha Ostrander.
David Barnett, father.
Okay. My understanding, Ms. Danke, you are going to make an oral motion today?
Your Honor, based on the information that's been provided to me from the Department of Human Services, I'm requesting that the court amend this petition to temporary at this time and amend the allegations. I've sent a copy of the proposed amendments to the allegations to Mr. Way and Mr. Kelly and to your court officer. This is a matter that I believe the initial allegations pulled information from a variety of old reports, and the information does not accurately reflect what the reports reflect, and that it would be in the best interest of Cameron Bliss for this to be treated as a temporary petition, and my client is willing to admit to court jurisdiction based on the disruptions that Cameron has experienced through this investigation. Additional services are necessary. Judge, with respect to the other two children, I believe based on the conversations we had in chambers, those children are going to be placed for a different day, and my client will be doing a release on those children.
Thank you. Mr. Kelly, are you in support of this motion?
Your Honor, under the circumstances as we had discussed before, this seems to be the most reasonable and prudent course to take at this time. So I'd have no objection to the motion that has been proffered to the court by Ms. Danke.
And Mr. Way?
Thank you, Your Honor. This is for the Department of Health and Human Services a mandatory petition, so we cannot support the position. I certainly understand. I've shared my thoughts privately. I believe most of what has been articulated is correct. My only concern with the allegations that Ms. Danke submitted is that it focuses a lot on Cameron. I also don't know that, I believe there was well, I'm sorry, no, so most of that is accurate. My concern is that I thought we were going to include something about that there were allegations made against the father at least, because I do think that what we discussed was some sort of service plan. A proposed service plan has been presented to Ms. Danke and Mr. Kelly. As long as, I guess, we are going forward with that service plan and we're doing this all with that understanding, then I think that, that those are sufficient to take jurisdiction. I just want to make it clear that the expectation, my expectation, and I think what we discussed yesterday was, although I know the father wants Cameron back in his care right away, was that there would certainly be a service plan put in place. And I believe Mr. Kelly and we talked about that this morning. I think that's, I think we agree on that. Thank you.
So, Ms. Danke, were you prepared to have your client enter a plea to the amended petition today at this time?
Yes, Your Honor. And I can certainly, if the court and Mr. Way are more comfortable, I can certainly add a paragraph that indicates that allegations of sexual assault were made, no proof was presented. If this case becomes a request for termination, those would have to be proven at that time. Would you prefer to have that in there, Mr. Way?
I would, just because I think it more accurately depicts what we need to do in order to service the family properly. Thank you, Ms. Danke.
Okay. Just take me 1 second and I'll forward that.
But this is just on Cameron only, right, Judge?
Yes, the plea is only as to Cameron. So, Mr. Barnett, while she's doing that, I'm going to start the process of accepting your plea. Would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name for the record.
David Barnett. David Allen Barnett.
Shannon, can I have this file? So, are they right here? Okay. You are the father of Cameron Bliss, born December 28 of 2009?
Correct.
And was Cameron found in the county of Jackson at the time the petition was filed?
Yes, he was.
Have you read the petition as it's been amended today? And do you understand the allegations that are being made against you?
Yes, Your Honor.
If the court accepts your plea today, there will not be a trial, and therefore you would be giving up the rights that you would have at a trial. Those include the right to a trial by a judge or by a jury, the right to have the petitioner prove the statements in the petition by a preponderance of evidence, the right to question the witnesses who testify against you, and the right to give testimony on your own behalf, and the right to have witnesses subpoenaed who you believe would testify in your favor. Do you understand that you will be giving up all these rights if I accept your plea today?
I do.
If the court accepts your plea, the following consequences might happen. There will be continued investigation by the caseworker to see what the problems are in your home and family and how and whether they may be solved. The case could be dismissed if there's no need for further court involvement. If there are problems in your home and family that can be solved, the court could make your child a temporary ward of the court, place him with either parent, with relatives, or in foster care, and order programs and services designed to solve the problems. If the court determines you are unable to provide your child with a suitable home within a reasonable period of time, the court could terminate your parental rights, and your plea can be used as evidence in a proceeding to terminate your parental rights. Do you understand each of these consequences?
I do, Your Honor.
If your parental rights are later terminated, your obligation to support your child will continue until a court modifies or terminates that obligation, until an order of adoption is entered, or until the child is emancipated by operation of law. Appellate review is available to challenge an order of disposition following adjudication, and such a challenge can include any issues leading to the disposition, including errors in the adjudication process. If you wish to seek appellate review and cannot afford an attorney, one will be appointed to represent you on appeal and to assist you in obtaining court transcripts. You may be barred from challenging the court's assumption of jurisdiction on appeal if you do not file a timely appeal of the initial dispositional order. Do you have any questions about anything I've told you so far?
I don't, Your Honor. Thank you.
Has anyone threatened you or promised you anything to get you to enter a plea today?
No, Your Honor.
Are you entering this plea of your own free will?
I am.
Ms. Danke, could you establish a factual basis?
Thank you. Yes. Mr. Way, I sent you an email with that revision. Is it okay? Then I'll go ahead and send that to the court as well. Mr. Barnett, are you the father of Cameron Robert Reed Bliss?
I am.
And what, at the time that this original petition was filed, was he located here in Jackson County?
Yes, he was.
And his mother is Denisha Ostrander?
Yes, she is.
Okay. And Cameron was removed from your care and placed initially with your grandparents due to an investigation that DHS was doing. Is that right?
With my
Your parents, his grandparents, yes?
Yes.
And then he ultimately was then placed with his mother, Denisha Ostrander.
Yes.
And then because of some problems that occurred in her home, she requested that he be removed. He went back to your parents.
Correct.
Is that right? Would it be fair to say that both you and Cameron have experienced a great deal of disruption and mental distress as a result of everything that's been going on?
Absolutely.
And in order to avoid any potential risk of abuse or neglect in the future, does your family at this point need additional services and support from the court and from DHS?
Yes, ma'am.
Thank you. I have no further questions.
Counsel, do you believe the court has complied with MCR 3.971?
Yes, Your Honor.
Yes, Your Honor.
I do accept this plea. I find that it was knowingly, understandingly, and voluntarily made, and that the record supports that one or more of the statutory grounds in the petition are true. I will be ordering amendment of the petition to temporary jurisdiction as it pertains to Cameron. We will schedule a further hearing as it pertains to the other two children. Are we, sorry, Shannon?
How far up do you want the other?
I think we'll be ready pretty quickly. A week sufficient to get the release paperwork together?
I would ask for maybe 2 weeks, Your Honor. That way, I think that'll just give us ample time to prepare it, get it to Ms. Danke, have her client come in and sign it.
Okay.
February 8th at 1 p.m. for Schuler and Harrington.
No, not February, 2 weeks.
Yeah, not February, December 8th. That's what that is what I meant. December 8th at 1 p.m. for Schuler and Harrington.
December 8th at 1 p.m. Are we prepared to proceed with disposition today as to Cameron?
Yeah, yes, Your Honor. I sent recommendations to Ms. Carroll, Ms. Danke, and Mr. Kelly. I don't know if Ms. Carroll receives them. I can resend them.
She's got them. Everyone has had a chance to see those recommendations.
Yes, Your Honor.
Yes, Your Honor.
Any objection?
No,
Your Honor. I just wish to address the visitation issue.
Go ahead.
They are requesting continued supervised visitation. My client has been participating in supervised visitation. We've received updated reports regarding that visitation from the visitation supervisor, they are very positive. It appears that Mr. Barnett does an excellent job of redirecting his son when his son is being disrespectful to other people, when his behavior gets a little out of control. He's the only one who seems to be able to manage and reset that. We're about to head into major holiday time with Thanksgiving and with Christmas. He's currently placed with my client's parents. And I know because of the mental health issues that Cameron's been experiencing, he's really been struggling in that placement. My client has been having contact with the child's therapist as well. We're requesting, he's fine with doing all of the services that they've requested. He'll get on those as quickly as they can get those set up. But we're requesting that if the court is not looking at a return home today, that the court move visits to unsupervised, with the agency having the discretion to return home at the recommendation of the child's therapist.
Mr. Kelly, would you support?
Yes, Your Honor. Thank you.
Mr. Way?
Your Honor, I have no issue with discretion for unsupervised parenting time at this point. We are early. I would like to see some counseling on the father's side. I would just like to see how things go. I think Ms. Hines, the worker, I do agree with Ms. Danke that the parenting time has gone really well. I do think that we should be using the designee as much as possible, especially on the holidays, so that Mr. Mr. Barnett, I'm sorry, his last name was escaping me, should have as much supervised parenting time as possible during the holidays, given that the child is with his parents. And I think if Ms. Hines deems unsupervised parenting time to be appropriate, she will certainly exercise that. Thank you.
So I will grant discretion both for unsupervised and for return home if supported by the child's therapist. And I would, given that placement is with Mr. Barnett's parents, that if supervised by his parents, it should be liberal. Mr. Barnett should be allowed to stay in the home, be with his son through the holidays, and the grandparents of the child are certainly suitable supervisors.
Thank you, Your Honor.
Okay, and our review hearing for Cameron will be
February 23rd at 9.
February 23rd at 9 a.m. Thank you all.
Thank you.
Thank you.
Mr. Barnett, we're all set. I'll give you a call just a little bit later today.
Okay.
Did they send you an updated? Susan was going to send it, I think. Okay, next up is Joseph Early. I saw Mr. Early in the waiting room. We'll let him in. Let's see. We have Ms. Tyler, rather. And Ms. McCluskey.
They got me in court. They just, all right, talk to you soon. Bye.
Okay, this is a matter of Joseph Early. Could each of you please identify yourselves for the record?
Matt Way, Prosecutor's Office.
Mia Tyler, DHHS.
Ivan Brown on behalf of Ronald Early, father.
Mike Kelly, guardian ad litem.
Rebecca McCluskey for Ms. Chambers.
Oh, and I'm sorry, Ms. Chambers is there. Let me get her in. Ms. Chambers, you can hear me?
Yes.
Okay. So, this is a matter of Joseph Early. Mr. Kelly, how's Joseph doing?
Your Honor, this is one of those early review hearings that we had, so I didn't have a chance to get a hold of Dad to see how things are going with Joseph. This was called early because of concerns about Mom coming around still. So I would wait to hear from the agency on that.
So what information do we have about those concerns, Mr. Way?
Your Honor, I would defer to Ms. Tyler. I know she sent an updated court report this morning. I don't know if everyone has a chance to look at them, but there were a couple of things that I think the agency has concerns with, and given the long-standing concerns that have existed, the multiple removals, we just wanted to address this with the court either via an early review hearing or a show cause before resorting to yet another removal and another disruption. So I would, Ms. Tyler, could you explain your concerns on the record and what you've observed regarding that?
Yes, I can start with Joseph. I did do an unannounced visit at Ron's house last week and got to meet with Ron and Joseph. He is doing well. He's actually participating in services at Loudtorn, and I did get a chance to contact his teacher. He's participating. They have no concerns. I have concerns with Mom. At the beginning, right after court, Mom was engaging. We were communicating just fine. And then it kind of just dropped off. I would contact her. She wouldn't respond to text messages. She wouldn't respond to phone calls. She would say she would meet me. And then when that time came, she would send me a message after 5 o'clock when I'm not working, apologizing for not meeting with me prior because her phone was dead. And I just have had the runaround all the way around with Mom. She's saying that she's working, which I'm not disputing. However, she does not work 24 hours a day. Therefore, she should still be engaging with this worker. It's just been her just not participating in services at all with the agency.
And Ms. Tyler, can you explain the concerns that you had that she's been in the father's home?
Well, yeah, so it was brought to my attention some pictures that Jessica Chambers had posted on Facebook where she is inside of Ron's home taking selfies. And the reason why I know she was inside of Ron's home is because I know what his home looks like. I've been in the rooms, I've seen the setup, and those are the same pictures that were posted on Facebook.
It really was an older day, though.
And did you also, I believe there was a reference to you seeing them leave his home in a vehicle. Is that correct?
Yes. So I was doing an unannounced visit to the home. And on my way there, I seen Jessica and Ron leaving the home. And of course, I turned around to make sure that it was them, and it was. I cannot say whether or not the child was in the vehicle because I could not see in the back of the vehicle, but I could clearly see that it was Ron and Jessica, and it was at roughly like 8:20 in the morning.
So those are the concerns, Your Honor. I mean, there's obviously, they're circumstantial, but they're very concerning. We've gone through this over and over again, and I don't know how much clearer we can be that this kind of thing just can't happen. So we wanted to bring that to the court's attention and
Ms. Chambers, wait your turn.
Have the court address it however it sees fit, rather than resorting to a more significant option. Thank you.
Judge, yes, I can explain. And I realize Ms. Tyler has always been a fair worker, not the kind of gotcha type worker some are. So I have a lot of respect for her. But the situation is, with regard to the pictures, those were not pictures of any current nature. I don't know when they were taken, but they surely were not taken since this court issued a removal from the home. What happened on the day that Miss Tyler saw Mr. and Miss Chambers and Mr. Early? What she said is coming from the home. What happened is Mr. Early went and picked Miss Chambers up to take her to the Victory Clinic. He forgot his phone at home. So he went back into the home to get his phone. Miss Tyler saw Miss Chambers sitting in the vehicle, not coming from the home as was put forth here today. I think that's a little bit of, in her report, it's correct, but her statement here today is a little different than what's in the report. Mr. Early knows, I have put it through his head. He understands she's not supposed to be there. And further, what hasn't been said is Miss Tyler has made many unannounced visits early in the morning, later at night, went through the home. He's always been cooperative with her. He realizes that the agency's eyes are on him, be it neighbors or whomever it may be. He's took her through the home. None of Miss Chambers' articles are in the home. It's just, this is a misunderstanding. And I've told him that if he has Miss Chambers in his car, he is not to go to the home unless his home is on fire. And he realizes that. This was a simple situation. Joseph was not there. You can check with the babysitter that Joseph was not with Mr. Early at that particular time. Thank you.
Well, I've got concerns, particularly based on what looks like a lack of honesty on Mr. Early's part. According to Ms. Tyler's report, when she saw Mr. Early and Miss Chambers together in the vehicle, she called both of them. Neither one of them answered. Your client then called her back and told her he had not had contact with Jessica, doesn't know where she is or what she's been doing. Based on what she reports, that has to be a flat-out lie. So how am I to believe anything that he says when he wasn't honest about that? If it was as simple as you described, he forgot his phone, was assisting her in getting to the Victory Clinic, and why wouldn't he say that? Why is he lying about it?
I don't know the circumstances, and I wouldn't characterize it as a lie. I'm just saying it was a misunderstanding. And I would point to the court that the many times that Miss Tyler has been there, and it's obvious Miss Chambers doesn't live there, or she's never caught Miss Chambers anywhere near the home on unannounced visits.
Can I speak, Your Honor?
Go ahead, Ms. Tyler.
As far as unannounced visits, I've made one unannounced visit, which was last week. And then two of my coworkers made two unannounced visits over the weekend. Other than that, there has been no unannounced visits to his home. So there has not been many unannounced visits. Normally, because Ron is usually very cooperative, I can usually call and set up something with Ron because of his work schedule. And I would go to the home after something has already been scheduled. So there has only been 3 to this day unannounced visits.
So, Mr. Early, I want to address you. it's clear to me over the progress of this case that you have feelings, you care about Ms. Chambers, and I get that. I get that. The problem is Ms. Chambers is not engaging in services. Her behavior demonstrates that at some point, I'm just going to have to call a halt to this, probably do some kind of a custody order. But I have zero confidence that the moment DHHS is out of your life, that you're not going to welcome her back into the home and expose your son to her. I get that you care for her. I get that you have feelings for her. But the reality is she's not fit to be around your son. And if I don't have confidence that you get that you finally realize that that's the case, I have serious reservations about what the future holds. It's clear to me, based on Ms. Tyler's report, that even though there's no evidence that you've allowed Ms. Chambers recently around your son, I do have questions about the Facebook posts and the indication she's in your home. You may say those were taken earlier, long before the court's involved, but the problem is I have zero confidence that I can trust what you're telling me. The best I can tell you, sir, is I don't want to hear any more of this. I don't want to see any further indication that you're allowing Ms. Chambers back into your life, plain and simple. Because if she's in your life, she's going to be in Joseph's life. And in her state, that simply is not acceptable. I would hope that she could get the help she needs, that she could finally get off these opiates. I realize how strongly addictive they are, what a challenge it is to break free from these things. I get that. But at the end of the day, what I care about is Joseph being protected, that he is not exposed to that kind of behavior. I know I've given you speeches in the past. I question whether they're really sinking in, but let me tell you in no uncertain terms, if this happens again, in all likelihood, what's going to happen is Joseph is going to be removed from your care. Take heed, sir.
Okay.
So we've done an early review hearing. I believe all of the recommendations are, well, let me ask, counsel, do any of you have objections to the recommendations?
No, Your Honor.
No objection.
No objection.
All right. I will implement them. Shannon, we can set the, oh, wait a minute.
We already have one.
Well, we do, but it's in January.
When do you want me to set?
Well, I'm looking at the order.
The order's not right because I didn't get the right report.
But there's references to a pretrial and.
Yeah, there's a pretrial.
There is a pretrial?
For Dan, he wants a jury trial.
Oh, that's right. Sorry. So we still haven't adjudicated Mr. Early.
I think it makes sense to leave the January date on just to kind of keep a close eye on things, Your Honor. That's my thought.
I agree.
All right, we'll keep the January 12th, 8:45 review hearing in place. There is also a pretrial set on March 2nd at 8:30. Hopefully we'll have a much better idea then as to realistically when I can actually conduct a jury trial. Anything else today?
No, Your Honor.
Well, thank you, Your Honor.
Okay, thank you.
Thank you, Judge.
Okay, next up is Sophia Johnson. Let me see. I see Mom. Let me let her in. And let's see, Ms. Fidawa. We'll let her in. And I think everyone else is present. Okay, this is a matter of Sophia Johnson. Can each of you identify yourselves for the record?
That way, prosecutor's office.
Alexandria Fidawa, DHHS.
Ken Hotchkiss on behalf of Mother Marissa Johnson.
Ivan Brown, LJL.
Okay, so is this an early hearing? I don't recall why. I don't have a report.
There was a removal.
Oh, okay. There was a removal. I got you. And that's the process for reviewing a removal following a case that's been adjudicated is that a dispositional review hearing has to be held within 14 days, at which the parent has the opportunity to challenge the removal. Mr. Hotchkiss, is your client challenging the removal?
Your Honor, I've discussed the allegations in the supplemental petition with my client. She does not challenge the removal.
All right. Let me see the order that was entered by the referee. There has to be at some point an approval of the petition. Normally we do that in a order after adjudication. I will simply sign the petition indicating that I have approved the supplemental petition. Looks like that's the only place well, that doesn't even make sense. I will put in today's order that I am authorizing the supplemental petition. We have, are there any changes to the ongoing recommendations as they pertain to Mom? Are those still appropriate?
Your Honor, I know there's been discussions. Mr. Hotchkiss and I exchanged emails this morning, and Mr. Brown has been included in some prior communication. I think everyone is in agreement to a goal change to guardianship. Sophia is placed with her maternal grandparents? Okay, yes, maternal grandparents. Ms. Wallenwein Johnson has some issues that she needs to work on. Nothing that would probably warrant termination. There's definitely a lot of tension within the family right now. And so I think what the agency is asking, and Ms. Fidawa can correct me if I'm wrong, but we're asking for a goal change to guardianship. And we would also ask, there have been some communication issues between the mother and placement and Sophia. And so we would just ask, like we do in almost all guardianship cases, that parenting time and any communication between parent and child be left at the discretion of the proposed guardian. Thank you.
Any objection to that recommendation?
I have no objection. Mom did so well throughout the course of this case. If she's willing to do that, I have no objection, but I don't I think it's too early to give up on her if she still wants to try. She did very, very well. And then as soon as Sophia came home, shortly thereafter, she had an alcohol relapse. I hate it for her because she did so well. But thank God that we have maternal grandparents that will keep close contact. I just want her to get the help that she needs. And if DHS is able to assist her, I'm willing to keep the same goal. But I will leave that up to Ms. Johnson and Mr. Way. Thank you.
I guess I didn't interpret this as giving up on mom. I think it was a recognition that there are some real challenges in her relationship with her daughter. Am I reading that correctly?
I think the challenges are more with maternal grandmother than mother. Political.
I think there's a variety. I think all of it is kind of happening. And I think Ms. Johnson needs to address her mental health. And I think that's kind of exacerbating some of those issues right now. And the reality is, and I know Ms. Fedowa told me this morning that we're 6 months out from a guardianship, so we can continue to service Ms. Johnson. Like, that's not an issue. And if something were to fall apart, then maybe reunification is an option in the future if things change. But I guess I'd be curious as to Mr. Hotchkiss's thoughts too right now.
Your Honor, I did discuss this with my client yesterday. I discussed with her the proposed goal change of guardianship. She seemed to be in favor of it. I don't know if that will change as she progresses through maybe a service plan. Her thoughts may change, but as of yesterday, and she can certainly feel free to speak up today, but as of yesterday, she was in favor of a guardianship going forward. Thank you.
And Ms. Fedowa, has the licensing process begun for the grandparent?
Yes, the grandmother is a licensed foster home. However, I double checked guardianship policy. I cannot apply for a subsidized guardianship until Sophia's in placement for 6 months, 6 consecutive months.
Okay, so it's not just the licensure has to be in place for 6 months. There has to be placement and licensure for 6 months.
That is correct. Rules are slightly different based on funding source, but both funding sources require the licensure and placement for consecutive 6 months.
All right. Well, there being no objection, I believe a goal change currently so that we can move towards a subsidized guardianship if indeed the goal remains that. Again, I don't see this as giving up on mom. I think we're all pulling for her continued sobriety. We realize that the road to sobriety has occasional relapses. I hope and trust that that is just a temporary failure. I think my impression of mom from prior hearings is that she realizes how destructive alcohol has been in her life and truly does want to achieve sobriety. So we will continue services as previously ordered. I will change the goal to guardianship under the current circumstances, and with the mother's support, I believe that's appropriate. And we will set our next review hearing for February 9th at 9:15. Anything else today?
Your Honor, just real briefly, I wanted to, because we've run into this issue in the past, but I think we would all agree that adoption isn't really a realistic goal here, given the child's age and the placement with a relative. And I was also seeking for clarification on parenting time. It would be my recommendation that parenting time would be left to the discretion of the proposed guardian.
I think that's appropriate. And you wish to speak to that, Mr. Hotchkiss?
I think that's appropriate under the circumstances, Your Honor. Thank you.
All right, thank you for reminding me of that, Mr. Way. Okay, thank you.
Thank you.
All right, next up is the matter of the Reyes minors. I know Mom's out there. Let me get her in. And
Hello.
Ms. Legore. And as soon as we have that audio connection, we will move forward. Okay, Ms. Legore is now present. Ms. Reyes is also present. Counsel, can you identify yourselves for the record?
Matt Way, Prosecutor's Office.
Rebecca McCluskey for Stephanie Reyes.
And Mr. Kelly, you're muted.
Mike Kelly, guardian ad litem, Your Honor.
All right, this was a date and time set for receipt of a petition seeking termination of parental rights. The court is in receipt of that supplemental petition. Has everyone else received their copy?
Yeah.
Yes, Your Honor.
Yes, Your Honor.
All right, the court accepts the petition, and we will hold a termination hearing on December 8th at 1 p.m. We'll also be holding a bench trial for Jaden at the same time.
Okay.
Your Honor, I do believe Ms. Legore wanted to address parenting time in the meantime.
Go ahead, Ms. Legore.
Yes, good morning. The foster parents are still just reporting concerns about COVID safety. They have some pre-existing medical conditions. We have done ongoing safety planning, but they want the court to know their concerns, and they do want to ask for virtual visits.
We can't do the virtual visits after we hear her.
I'm sorry, Ms. Reyes, say that again.
We had attempted to do the virtual visits from March through June when there was the original order about having to suspend the visits due to COVID. And with my mom's audio setup, I can't hear my daughter when she's talking to me. Like literally, she was up at the computer monitor as close as she could get, and I couldn't understand anything she was saying.
So, Ms. Legore, is that something you could personally investigate? Maybe they don't know how to adjust the setting.
I can try to help, but I do want to verify what Stephanie said, that they did have difficulty back in March. So it's something that in March we resorted to phone calls, but that does change the quality of the parenting time.
Right.
One possibility, and I mean, I do this with court hearings routinely when I've got someone who's got a visual connection but a poor audio connection, we'll incorporate both the telephone and the video connection so you can
I don't have a computer. I don't have a computer or any way to do an audio and visual simultaneously because it's just my cell phone.
So
the only way I can do that is either through I'm sorry?
You use your cell phone to make the visual and audio connection?
That is correct. Yeah, we were using Facebook Messenger, the video call through Facebook Messenger since my mother's on my Facebook account. And Brooklyn was saying that she could hear me perfectly fine, but I couldn't understand anything that she was saying. Like, she was, you know, my mom had even come on the computer and she got really close and she goes, she's almost yelling. Like,
And so it wasn't that the voice was breaking up, it was just that the volume was low?
that is correct.
Well, there are volume settings on both devices, and you have to
Yeah,
make
my
sure
volume
that
was all the way up.
All right, so maybe she was having trouble understanding how to adjust the volume on hers?
I don't know, because I had even tried hooking up a Bluetooth speaker, and the Bluetooth speaker itself wouldn't connect to my phone while I was using the talk mode. So I don't know if it was just like an incompatibility or what was going on.
All right, so Ms. Legore, if you could attempt to assist to see if we can get this fixed. I'm sympathetic to the concerns about COVID exposure. We're only looking at 2 weeks anyway until I conduct this hearing, or 3 weeks. I am going to order that the visits be virtual, but I want every effort to be made to make sure we make it a good connection.
Yes, sir.
So may I ask a question in regards to that?
Yes.
We do have our visit scheduled for today and Wednesday from 2 p.m. to 4 p.m. Are we going to try and stay virtual for those 2 hours, or how exactly will this work?
The visits are going to
Like,
be
do I
virtual.
need to anticipate doing? Do I need to anticipate doing a physical visit this week, like we had already talked about and scheduled, or?
We'll do virtual, and I will call to discuss scheduling, because 2 hours is a long time for the kids.
Of course.
So we could do more shorter visits.
Yeah, more shorter visits,
right.
or more shorter numbers. I got it.
Okay, thank you, and we'll see you back here on December 8th.
Thank you.
Thank you, Your
All right,
Honor.
thank you, Your Honor.
Okay, and that brings us to our post terms. The first is Jordan Harbert. Let me let Jordan and Dr. Miller in. And Joy Jennings. And let's see, I've got Maria Kleckner. Is she involved? Does anyone know? I'm going to let her in any event. Okay, this is post-term for Jordan Harbert. If you would give me just a minute, I'm going to step away, but I'm going to keep this on the record. I need to take a very short break. I'll be right back.
I figured out as much.
Shannon,
Ivan?
on December 1st and December 8th, Chris will be handling my couple matters that I have.
Okay.
I will be available if there's an emergency, but will you, if we have any prelims, will you send them to him?
Yep, I'm gonna make a note of it right now, Ivan.
Okay. And Dr. Miller?
So you said the 1st and the 8th, right?
Correct.
Okay, yes, I'm making a note right now.
Dr. Miller?
Yes, sir.
My name is Ivan Brown, and I was given your telephone number by another client I have, who I'm the LGAL, Keith Moore. Are you Dr. Paris Miller?
I am.
Miss Molly Wagner gave me a wrong number, and I'm waiting on her response. I'm wondering, could you text me your correct number so I can talk to you and Keith at some point in time before our next hearing in 2 weeks?
Sure.
Okay. You can text me at 517
517
262
262
1894.
1894.
The number she gave me, 248-373-4074, says it's not in service at this time.
That's not my number.
Okay, I don't know why she gave it to me because I checked twice, but thank you.
Uh-huh. I'll send you my number.
Okay.
Do you have my email address?
I was just taking control. I love it.
Okay, folks, sorry about that. We're back on the record. Let's see. Could each of you identify yourselves for the record?
Joy Jennings, Jackson, DHHS. Maria Kleckner with Family Service and Children's Aid.
Ivan Brown, Special Advocate.
Mr. Guardian ad litem.
Dr. Paris Miller, Director of Havenwick's Residential Program.
Hi, Jordan.
Say hi.
Hi.
Jordan, how are you doing today?
I'm doing good. How are you?
Good, thanks. I have a report and recommendations from the Foster Care Review Board. Mr. Kelly, I assume you've had an opportunity to see this?
Yes, Your Honor.
They have some very specific recommendations. First of all, consideration of a Thanksgiving visit for Jordan in his grandparents' home. So, Ms. Jennings, what's your view of that?
I'm sorry, my connection cut out for a second. The agency did discuss it with Havenwick, and currently they are not allowing any children to leave campus because of the COVID-19 concerns and cases rising. And the therapist is trying to arrange for the grandparents to come to Havenwick for a visit soon.
These are indeed unusual times. The other specific recommendation was whether or not there is a less restrictive environment available to Jordan other than Havenwick. And we know where that comes from with the initiative by DHHS that grew out of the terrible incident that occurred in, I think it was Kalamazoo. So Dr. Miller, yes.
Yes, Your Honor. I need to amend the report in the sense that after the report was written, Jordan propositioned staff and said he wished to have sex with her in front of his group. He dropped to 1R, which is level 1 with restriction. I know it says level 2 in the report, but it should be clear to all of us that his sexual impulses remain out of control and that he's at unbelievably high risk to act out in a sexual manner. So I just wanted to add that information to everybody's knowledge base.
So your assessment is that at least currently there is no less restrictive environment than Havenwick for addressing Jordan's impulses.
Beyond a shadow of a doubt.
Anything you wish to add to that, Ms. Jennings or Ms. Kleckner?
The agency is in agreement with Havenwick that Havenwick is the least restrictive at this time due to his behaviors. We will continually be assessing his progress in hopes that we will be able to place with his grandparents down the line as a less restrictive placement for him.
Anything to add, Ms. Kleckner?
I would just agree with Ms. Jennings and Havenwick as well. I think that we've seen periods of time where there have been progress with Jordan, as evidenced by him being able to move to a level 2. So that's good, but given the recent setbacks and the fact that the program is a 6-level program and he's at the beginning of those levels, I would agree with the recommendations given.
Mr. Brown?
Judge, I continue to advocate for implementation of Dr. Henry's recommendation. There was some talk about doing a re-review with Dr. Henry. The court indicated that you couldn't believe that would still be Dr. Henry's recommendation. I disagree with that respectfully. I think this is the only time in my tenure that we've ever disagreed with Dr. Henry and see where it's gotten us. Thank you.
Your concerns are noted, Mr. Brown, but are based on all of the information available to me, I still believe that for the present, Havenwick is the least restrictive and necessary placement for Jordan until he can learn to control his impulses. Releasing him into a non-secure environment will put other children at risk and will put Jordan at risk of being criminally prosecuted for deviant sexual behavior. I don't want that to happen to him. He's got enough problems to deal with criminal law. I appreciate the concerns. It's extremely, extremely distasteful to the court knowing all that Jordan has been put through in his short life. To be in this position, it grieves me terribly. The last thing I want to do is punish Jordan. Jordan has been punished enough in his lifetime. I get that. But I want him to be protected. And I realize being in a secure placement as he is probably feels like punishment, but that is absolutely not the purpose. The purpose is to provide whatever resources can be provided to assist Jordan in living a normal life. That is our goal. So I will specifically address in my order the issues that were raised by the Foster Care Review Board, and I will set this matter for our next review hearing, February 23rd at 8:45. Thank you all. Jordan, I do wish you well. I realize this is hard. It's hard for me, but I wish you well. That concludes our hearing. Thank you.
Thank you.